And our next presenter is Kamran Adil. He is a police officer by profession. He did his BCL at Oxford University, and currently he's serving as DIG police in Islamabad. He is an author of numerous articles, and it's really great that we have him with us. We are really grateful to you, sir. And Kamran Adil would be talking about CRPC. Sir, over to you.
Thank you, Zubair. It is a pleasure to be part of this session. The title of the topic is CRPC, but when I looked at the syllabus that was shared for this particular GAT test, uh, it is about criminal law. So I'll try to quickly and conceptually cover both the areas. I would like to share the screen. So first is the conspectus, then criminal justice system briefly, then Pakistan Penal Code, which is the criminal law of Pakistan. The first and foremost question is about the constitutionality of criminal law in Pakistan. Most often than not, people tend to believe that this is a provincial subject. If you look at the constitution, in post 18th amendment, new article 142 and 143, they were rewritten. The articles were old, but they were rewritten. And after abolishing the concurrent list, these criminal law, criminal procedure, and law of evidence, these three areas were brought under a concurrent scheme. So when people talk about criminal law in provincial sense or in federal sense, that makes little sense. It has to be a shared responsibility, and its constitutionality is very important for students to know before they take off with the preparation. Another very important concept is offense and crime. Usually people tend to talk more about crime and less about offense. For practitioners, offense is the real important concept. Offense is defined in section 40 of Pakistan Penal Code as anything that is prohibited and punishable under the law. If anything is only prohibited but not punishable, it does not qualify the definition of offense. So it's very important to focus on offenses. Crime is a social terminology, and if we look at Pakistan's law, we are all the time talking of the offenses. So I would urge upon the students to please look at the offenses and keep in mind the background of crime. All crimes are offenses, but all offenses are not crimes. That's my statement, and sometime we can talk about the niceties of this. Second is the relationship between PPC and Code of Criminal Procedure. PPC, Pakistan Penal Code, is the substantive law. Code of Criminal Procedure is essentially the adjective law or the procedural law. So they both complement and supplement each other. Substantive law comes in place first, and obviously then the procedural laws helps it out. Sequencing and codified, these are codified laws. As Chima Sahab observed in his talk, that the laws were codified, they were written, brought at one place. So codification has its own implications for understanding the law. This helps in many ways. One, it provides you a structure. Two, it gives you everything at one place. But obviously there are areas which remain out of it, and they are always they come in hard cases. They come before the courts. Then then is adding case law to statutory law for the students who want to gain more marks, and because this GAT is going to be MCQ type, so they should try to wear the statutory law on their sleeves, and they can always add to that the case law. The case law method that is taught when we usually study for the sake of these sections, it has to be used for the conceptual clarity. So this is the criminal justice system of Pakistan. If you look at the left side, we have offense, which is and offenses are catered in PPC, and all the other 5 components of the criminal justice system in Pakistan are on the right, and they come in their own place. So they cascade according to their importance. The first one is police, then prosecution, then courts, then prisons, and finally the correction system. So they all 5 components, they team up to give a particular flavor of a system. They're all interdependent. That's why they are called system. And this all this setup comes under provincial government, and through Home Secretary, who is head of a full department, full-fledged department. All these 5 components, they move in one direction, and then they try to achieve the objective of providing the legal justice to the victim. In Pakistan, the jurisprudence has been set more in the favor of accused, whereas the international trends are in the favor of looking at victim-centric approaches are now being introduced. So maybe we need to look at that at some other time, but just a food for thought. Pakistan Penal Code in the syllabus that has been shared by LOGAT, by HEC, there are three areas that are to be covered in Pakistan Penal Code. One is the general exceptions, the other one is offenses against person, and third one is offenses against property. Interestingly, these two categories, offenses against person and offenses against property, are the most commonly used by the police and by the general criminal law practitioners. So it's very easy to cover them. General exceptions have two limbs. One is the criminal liability limb, and the other one is the private defense. People usually call it self-defense, but the word self-defense is not written in Pakistan's law. The word is private defense, and it extends to both your life and to your property. So it's a very expansive concept, and I think we need to use the word private defense. I would always prefer it over that. So the scheme is this, that everyone is liable for the acts that he does, but there are some exceptions to this. For example, a child less than 7 years of age, he does not have the full criminal liability. So these all things then, these exceptions fall here, and that's why they are called general exceptions. Likewise, if anybody is lunatic, then is he liable for his acts? So all these concepts are stated in this first part of the Pakistan Penal Code. So these are general exceptions. And then private defense, I've already told that there are two categories: private defense to life and private defense to property. Then there are offenses against person. In this, there are three big categories. One is qatl. Under English law, common law, they're called homicide. And then there are different degrees of homicide and different nomenclature law of homicide. It is called qatl, and qatl has then five, and students have to take thematic grip of this so that they can score better in exam if they know the whole scheme. Then is the offense of hurt. Hurt is so this is very briefly. And movement of a person is also part of this your examination. In the in movement of persons, you are not allowed to move to a particular direction, then you are in a restraint, and if you are not allowed to move in any direction, then you are in a confinement. Then there are offenses against property. There are three big categories that are usually referred to: theft, robbery, and dacoity. Theft has the element of surreptitiousness, and it has its own definition. There is no use of force in this. There is no criminal force used in this. Whereas in robbery and dacoity, in both, criminal force is used, and the difference between robbery and dacoity is essentially of numerical. When there are 5 or more accused, then it is dacoity, and when then less than this, then this is called robbery. And almost all police officers, from the lowest ranks to the highest ranks, they're very well versed in these two categories of offenses. So this is very important that you take stock of this, so that you are able to have a good preparation. Police powers, then prosecution powers, then court structure. Then there is a long list of definitions, but one of the most important from the point of view of examination talks about what is investigation. Investigation is collection of evidence. Can collection of evidence by a layman amount to investigation? Is it going to be acceptable in the court? No. So there is this police and policing definition is not part of Code of Criminal Procedure. But it is a very overarching concept that students must take into consideration while preparation. Police is the name of the organization, and policing is the function. Police is the organization, and policing is the function. So policing is done in our country by many an organization. It is not confined only to the police organization. For example, drug inspectors, environmental inspectors, enforcement inspectors, all of them are doing policing. And while they are doing policing, they have to resort back to Code of Criminal Procedure to use their powers, the coercive powers of the state, the infamous coercive powers, or maybe the lawful coercive powers, whatever perspective you have. But that's the real nub. And I always request students to take a note of this important difference. Unless you take note of this difference, you will not be able to have a very good command on the concepts that are written in CRPC. So this is not written in CRPC, but this is going to help you as a tool to understand different concepts. Then police powers have been written in the Code of Criminal Procedure, and those powers, there are areas of powers, police powers. Um, the arrest is number one in your course, then escape, then research, then search, then production of records, then seizure, then security for keeping peace, and security for good behavior. The last two things, the security for keeping peace and security for good behavior, are essentially preventive powers, and they are based on police reports. Uh, and then the reports are written to the magistrate, and then the magistrate takes the cognizance, and he then gets the bond from the person who against whom the report has been initiated. The power to arrest, escape, search, production of records, and seizure. These five powers are very important, and they go back and they link to the constitutional law of this country and the fundamental rights and all the human rights discourse that we discuss in and out. Um, so these powers are to be exercised in a manner that there are no excesses. So arrest is first power under the law. If I am a police officer and I tell anybody that he's under arrest, uh, this is suffice um, to presume that he is under arrest. And when I touch him, or when a police officer touches him, then the procedure becomes complete. And after that, if he escapes, then he is liable to be. Then the police officer is authorized to use force against him. But the force is then the force that is to be used is then regulated by the principles of necessity and proportionality. If a person is running and he has done a small petty offense, you cannot go and kill him. So this is the proportionality side of it. And likewise, if he's just moving away, you cannot use, and he's an old man, elderly man, he's moving away, and you just can't take out your gun and fire at him. So these are the limitations which are there, and these limitations have been upheld by different case law. Uh, so this is very, very important that this power is used as per law, and then once the power is used, it has to be a justified arrest. If the arrest is not justified, then it is considered vexatious arrest under the law. And in Punjab, at least now under police order, it's an offense. And then often people talk about hot pursuit. Hot pursuit is limited to the territorial jurisdiction. Our code of procedure is very territorial in its approach, and one should be mindful of this. There are different debates about it, and we can always talk about it. Then the power to search. There are two types of searches: searching the person and searching the premises. So these are two different concepts. All the students are requested to have clarity on these two things. The search of premises has a safeguard in section 103 that there should be two people, independent witnesses, who come and in whose presence the search is carried out. And if the person is searched, then it has different parameters. For the search of woman, the search is preferably be to carried out by a lady police officer, not by male police officer. That's already provided in the police rules. So, but police rules are not in your course, but you should have this extra thing in mind, and maybe it helps you to then look at it. If you go and search out that rule as well, that rule is 26.1 in police rules. You might be getting more marks, and maybe if there is an MCQ framed in and around it, you may be able to do better in that. Then production of records. If you need record of say a revenue record, then there is a procedure for that. Or if you need, if a police officers need a bank statement, then he has to file an application under section 94 CRPC through a sessions court. The court will allow it, and only then it will be allowed. In different places, there are different ways of doing it. In Islamabad, it is the application is made to the registrar, and then it is placed before the High Court. But in Punjab, it is placed before the sessions judge, and he then exercises that power. If you look at the statute, the power is with the sessions judge, and these are two terms: sessions judge and court of session. So the sessions judge has to be sound like a plural, because this is the way we have received it, and we have done to follow that. And all these seven powers, they are always under the magisterial superintendence of the courts. Courts can always take them, and all these powers, once you use them, they have to be sanctioned by the court of law. If they are not sanctioned by the court of law, for example, if I arrest anybody, then he needs to be produced within 24 hours before the court. And if I produce him within 24 hours before the court, and there is no evidence, there is no justification, court has power to release him. So that's the mechanism that has been envisioned by the constitutional scheme to ensure that the people's right to security and right to life is properly exercised and enjoyable. Another third part of your course is public nuisance. This is very famous one, section 144 of CRPC. This is a sort of omnibus part, because the way the nuisance has been defined, it's very broad. And during this corona and this epidemic, all the powers of lockdown were used under this particular section of 144. So this is the very core that is being used by the administrators in the country. Most of the time, DCs, they issue these powers. Then their provincial governments also issue these powers. They issue the order, and the order is implemented by police officers by registering cases under section 188 of Pakistan Penal Code. So this relationship between CRPC and Pakistan Penal Code that comes into play. It's very important, and in field it is most often used law. There are very few convictions of this law most of the time, and its punishment is very less. So this omnibus law is used almost on everything. It has been effective, but then there are different debates about how it is to be used, and that subject is for some other time. But now focus on your exams and just understand the concept, so that you have some good understanding of this. Fourth concept is police processes. Police processes is a full domain. Most of the time in police training schools, we teach people from section 154 to section 173. These about 17 sections, they make the whole of the body of police law, police processes that they use on daily basis. It all starts with section 154, which talks about FIR, first information report. And that's why this section is styled as information to police. And the word FIR is not written within this code. It is coming from police rules. There's a form in which this word FIR has been used, but it has become more famous than the whole CRPC. But you should have that idea. So information to police, what police will do that with that information? Then once the police officer receives the information, then he has to filter that information into two things. Either it has to be a cognizable or non-cognizable information. And this, what is the test where it is written that what is cognizable and what is not cognizable? It is stated in Schedule 2 to the Code of Criminal Procedure, and that's why that is called scheduled distinction. So it is basically statutory distinction. If you apply logic, you can always apply logic, but you always have to go back to that Schedule 2, and you have to look at what exactly is cognizable and non-cognizable. And we often do that when we are in not clear, or we want to reconfirm it. Once the information is received, then it is converted into a registered case, and that registered case is called FIR. After registration of FIR, the investigation starts. I would like to you to recall the basic concept of investigation: collection of evidence by police. So everything that police does has to be documented, and everything is to be logged in police station, one of the registers of police station. There are 25 registers, so everything is to be logged properly. So what the police officers do, they after the FIR is registered, they start the investigation. They visit the crime scene. If there are any witnesses, they write their statements under section 161, and these statements are not to be signed. They are just indicative, and they are for the furtherance of investigation. And then based on this, they start their investigation. Maybe in one statement, they get to know about presence of two people there, then they start finding those two people. And once they are able to find those two people, then they would ascertain what were they doing there. If they become suspects, then they will be interrogated. Otherwise, they are usually interviewed. And after interrogation, if there is justification, maybe they are arrested. So this is the way it goes. So statement, and then there are two new sections that have been added in 2016 amendments in Code of this criminal law amendments, in which rape victims can now be their medical evidence is to be done, and medical officers are under obligation to do their to record their evidence. These medical officers have to be public sector notified medical practitioners. They cannot be private doctors. This point just is a footnote that you should know. Then DNA test. Then the suspect who has been alleged to have committed some sexual offense, he can use force can be used by police to get his DNA test. So these are two new sections that have been added. I have my hunch that these two questions might be asked in your test, 164A and 164B. Then the search in this case after registration of FIR is to be done under section 165, read with section 103. So that's this is the way both sections apply, and all the safeguards come into place. Then the famous or infamous police remand. There are two types of remands. One is called judicial remand, and the other is called police remand. Police can only hold a person for investigation for not more than 14 days. That is the time which is given for submission of final report. So within that time, they have to find the evidence, and then they have to uh, do their investigation and do their collection of evidence, and they can make an application to the magistrate or to the court, concerned court, criminal side, requesting the remand of an accused. That is called police remand, and this is usually, it is not given in toto. It is not given for 14 days. It will be given maybe in 1 day, for 2 days or 3 days, and the police officers, they keep making progress and they keep asking for more remand up till the total time of 14 days is complete. So this police remand is very important. After the police remand is done and the final report under section 173 has been submitted, then judicial remand, then the person goes on judicial remand if he is not admitted to bail. So this is very important to remember what is police remand and what is judicial remand. Then police, in cases where there is insufficient evidence, they can discharge accused. This is a very powerful tool, but police do not usually use it because of the accusatory environment and ecology in which police officers work. So, but this power is always there, and it should be, and it can be used in appropriate cases. Then the case diaries, everything is to be logged, and there are two logs. One is the log of the police station, the other is the log of the IO. So these two logs have to be kept, and they have to conform with each other. If there is any discrepancy between these two records, then obviously the acts done which do not fall within these two documents, they do not enjoy the legal cover. And then the police report is submitted. This report under section 173 is submitted. It has many names. Some call it chalan if there is evidence and a person is found, there is sufficient evidence, and the police opts to charge him for that offense. Then a chalan is submitted. If police finds that no occurrence has taken place, then a kharaj is or cancellation report is prepared. So there are different names which are vernacular in their origin. So these report names might be asked in the question paper. I would request you to please visit. You can Google it on the internet. Handbook of criminal procedure in Pakistan. It has been prepared by police officers. It contains all the vernacular styles and all the details. So if anybody of you likes to maximize his or her knowledge on this area, they can always do that. Then your course also contains about a topic about complaints. This is a very, very important area in case and because of our colonial past and lack of trust in police. There are areas when FIR is not registered, and in that case, the victim can opt to go directly to the court, and this process in Urdu is called istaghasa, taking the help, and they can directly go there instead of going to police. Instead of entering the criminal justice system through police, you can enter the criminal justice system through a court process, and that process is called complaints process. And then they have their own power, but the difference between the two processes is in complaints process, they don't have the powers to arrest. What they do is they will first summon, if there is a plausible case, then they will summon the accused, and they will see whether there is sufficient evidence. And if there is sufficient evidence, then they issue the warrant, and then the person can be arrested by the relevant uh, area in charge or police SHO. But ultimately, the arrest is to be done by the police. But in this case, it is court-driven process, and investigation is a police or executive side driven process. So these are two differences. Then comes the trial. Trial is a standard, a very structured process. Every bit of it is covered under the law. How the charges are framed, what happens when there are multiple charges, what happens if there is a big charge, what is the law of merger. The big charges, they merge, the small charges merge into the big charges. For example, if a person has been, first he has been hit by a car, he is injured, then he dies, so his injuries, they will merge into the larger and bigger offense. So that's the doctrine of merger there. Then how the charges are framed, then then the person is charge sheeted. When he's charge sheeted, then he or she, whoever is the accused, he is then given the evidence against him. For example, if there are statements under 161, they are given to him. All evidence is to be given to him so that the person can defend himself or herself. So that's the scheme of things. Then after this is done, then the onus of proof starts. Uh, the the thumb rule is that the onus of proof is on the prosecution, not on the defense, unless it is unless the defense calls for something. For example, if defense takes the plea of alibi, then the onus of proof to the extent of alibi is on them, that they were not at a particular place. This is called a plea of alibi. So then the burden shifts to the whoever alleges what. Then there is adjudication, and after adjudication, the whole thing might result into conviction or acquittal. In case of conviction, then sentencing takes place. If there is acquittal, then obviously, and then there are two types of acquittals: 249A acquittal and 265K acquittal. 249A acquittal is with the magistrates, and 265K acquittal is with the sessions court. Then appeals have been covered in this is also part of your course. Appeals, section 403 of CRPC says that you don't have, we usually use the word right to appeal, but in criminal matters you always have to go back to the statute to see whether this uh, appeal has this right has been conferred upon you or not. If it is not conferred upon you, then you don't have that right to appeal. So that essentially all appeals in criminal side are statutory appeals. And once you have that right, you have that statutory appeal right, then you can use that right. And then there is a difference between appeal and revision. Appeal is against the judgment of conviction or acquittal, whereas revision is against interim orders. For example, there is Spurdari order. Spurdari order is this the possession order for a particular thing. If there is a car that has been used in an offense, then you file an application before magistrate court under section 526 of CRPC, and you ask for this possession order from the concerned court. That is called Spurdari order. And if anybody wants to go against that, then again, if they go against that order of Spurdari, that is called revision. They will not go in appeal, they will go in revision. So against acquittals or convictions, there is appeal, and against orders, there are revision. So that's the difference, which I know you must you must all have read and you know this, but I'm just trying to remind this so that you have a quick recap of the whole subject. Then bailable offenses, it is clearly stated in the law that and this is section 496 and 497 and 498, three sections. 496 says that in every bailable offense, bail has to be granted. There is no option with the court not to grant bail in bailable offenses. And in non-bailable offenses, there are different grounds that they examine, and only then they grant the bail. And usually the thumb rule is that offenses up to 3 years, with the punishment of up to 3 years, they are bailable, and more than 3 years are usually not non-bailable. But you will always have to go back to the statute to recheck the punishment, and only then you should insist on this. Then there is a concept of pre-arrest bail. This is a product of case law. Judges have over time allowed this particular bail by interpreting the fundamental rights of the constitution stated in the constitution, and it's a very handy, useful thing, pre-arrest bail. But and then this is all coming from the case law. It is not based in the, if you look at the, if you try to find the exact provision for this, you will never find that, because it is coming from the case law, and it is read under section 497. Then no bail in NAB cases. For example, there is no provision in NAB law for bails. So what happens then is that in those cases, writs are filed, constitutional writs are filed, and then based on that, it's not an application for bail, it's a writ petition against the NAB, and the matter does not, the bails are not taken by the NAB courts. So this is very important, and this is one of the primary reforms that is being discussed as far as NAB law is concerned. With this, I come to end of these two things, CRPC and PPC. This is very important. The last thing, unless I do this, I think we will not be doing justice with this subject. This is constitutional criminal law. This is very important in other jurisdictions in the world. People have given a lot of respect to fundamental rights, and unless these fundamental rights really become they translate into actions, there is little meaning to the fundamental rights that we speak every day. The Constitution uses the word fundamental rights and not human rights. So most of the time, students I've seen referring to human rights. Constitution of Pakistan talks about fundamental rights, because fundamental rights are related to the state, and human rights are conferred upon you because you are a human being. So all the fundamental rights, all the human rights are fundamental rights, but all the fundamental rights are not human rights. And that is the reason some fundamental rights can be suspended at particular times according to the Constitution, and the situations are given within the Constitution. Then these are 6 or 7 principles that are followed as far as criminal law is concerned. These are the safeguards. First principle is principle of legality. Everything that is done has to be backed by law. As I submitted, that investigation is collection of evidence by police according to the law. They cannot do their own whimsical thing and they say that I think this is the, I collected evidence. They need enabling law to execute their parts. So this is the legality principle. This is at the very heart of our constitutional scheme. Second thing is security of person. This is the right to life, but the title in the Constitution is security of person. Then safeguards against arrest and detention. Arrest is different and detention is different. In detention, this benefit of this constitutional guarantee of 24 hours, protection 24 hours does not apply. In this case, judicial superintendence has been increased, and then they can supervise this area. Then after 18th Amendment, due process was introduced through a new article, Article 10A. Then slavery, forced labor has been prohibited. So nobody can be can be put to slavery. Likewise, protection against retrospective punishment. Retrospective punishment means that if a particular act was not offense at a particular time, then on the basis of that, you cannot prosecute anybody. When the act was committed, at that time it must be an offense. Otherwise, you cannot apply. So you cannot give punishment. So this is retrospective punishment. And then double punishment and self-incrimination. I'm sorry, my pardon. This is not properly written. Not double incrimination. It is double jeopardy and self-incrimination. So these are two different things. Double jeopardy is prosecuting person on the same charge twice. So this is double jeopardy, and self-incrimination is that nobody can be witness against himself. So these are some of the constitutional guarantees that have been granted under the law. With this, I come to end, and I just try to present it thematically. Zubair, I'm very grateful to you for allowing me this opportunity. I hope it will benefit the students and they will be able to get through their GAT test.
Thank you very much, Kamran Adil, for your wonderful presentation. This is really great that we are hearing about the law from a police officer who actually applies this law on day-to-day basis.